My name is Volker Kruger from Velden-Duffey, Tunis, and I have Thandeka Mpanza with me. We've had a couple of interesting, I think, discussions regarding labor law cases. This one, again, I think is an interesting one. Can an employee be fired for complaining too much? Yeah, surely not.
You'd be surprised, Volker. Well, good day to you and to the listeners at home. So this was a CCMA matter that was brought before the CCMA by an employee who continuously raised grievances at work. So primarily this dismissal, what the unfair dismissal was alleged to be based on, was incompatibility, which came in the form of the employee lodging endless complaints and displaying aggression towards his immediate superiors and so on. So in this matter, it's exactly that, where the employee had continuous disruptions and disputes with his employers, where he complained a lot, lodged continuous complaints, and the working relationship between the parties just seemed to be very incompatible. And ultimately, the employer resulted in dismissing him. And it was quite interesting in this matter because they relied on their code of conduct, in which they defined incompatibility as a form of misconduct. But yeah, essentially, the employee was dismissed by the employer. And it's also quite interesting to see that there were various steps that the employer had taken to try and fix the relationship between the parties. He had arranged counseling for them, for the employee, and even despite all of that, the relationship between the two of them just seemed to be incompatible, which led to the ultimate dismissal of the employee.
Right, so the conclusion of the CCMA was that it was fair to dismiss the employee.
Interesting enough, yes, indeed. The CCMA did find that it was fair to dismiss the employee. However, the CCMA noted that the evidence showed that the employer went out of his way to assist the applicant. Despite the efforts that the employer took, the poor work performance from the employee persisted. The low morale by the employee also persisted, and the employee had continued to file grievances after a successful conciliation meeting. For our listeners at home who don't know what a conciliation means, it's a process at the CCMA where the commissioner will sit down with the parties, the employer and the employee, and will try and reconcile the parties. We try and settle and try to iron out any disputes that the parties may have prior to the matter going for arbitration. So despite having that successful conciliation meeting where the parties agreed to bury old wounds and start paving forward towards a successful relationship, the relationship between the parties just continue growing toxic. But the CCMA, again, in their findings, relied on the case that was before the Labour Court named Jabari versus Telkom. And essentially what the case said is that incompatibility, which I'll read verbatim, says incompatibility refers to the employee's inability or failure to maintain a cordial and harmonious relationship with his peers. Incompatibility is a form of incapacity, and incompatibility is a Nobelius concept based on subjective value judgments. And therefore, relying on this judgment, the CCMA said that because of the intolerable relationship between the parties, the employee relationship cannot continue to exist, and they found that the dismissal was therefore fair and just in light of the evidence presented before it.
Okay, so I guess like with many other cases, you can't just read one sentence or one paragraph of the report. No? You've got to read the whole report to get the proper picture. No? So you can't just, as an employer, fire an employee if he complains once or whatever. You've got to follow a fair procedure. You've got to try to make sure that you do have a good relationship, which makes it possible for the employee to work for you, etc. But if despite those attempts and those actions, he still keeps complaining and is not cooperative, and there's a relationship that just doesn't work, then as employer you can dismiss that employee.
And that is indeed correct, Volker. And I think that is why the employer was successful in this matter, because the commission was satisfied that he took reasonable steps in trying to cater to their relationship, to attend to the employee's grievances. But even despite all those good faith efforts, it still failed for them to have a good relationship, and they cannot continue like that indeed.
Thank you, Thandeka.